Court does call the case. People versus Roman Hop.
Ashley Phelps for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hop. State your name for the record, please.
Roman Hop.
I have before me a plea form that indicates the defendant will be pleading guilty to the charge of malicious destruction of property. 200 to 1,000, which is the 1 year offense, which I think is the stated count. On a successful plea to that charge, at sentencing, the prosecutor will recommend a probationary sentence, and the victims are waiving any right to restitution in this matter.
That is correct, Your Honor.
All right.
That's our full understanding.
All right. Very good. May I have him sworn?
Raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so you got.
Yes.
Lower your hand, state your name.
Roman Hop.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of malicious destruction of property 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property destroyed or otherwise injured. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any questions regarding any of those rights?
No.
No? All right. On the podium, you'll see a copy of one. Please look at paragraph 5, the highlighted one. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily
Correct.
and of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
I'm sorry.
Yes, sir.
Yeah, okay, thank you. On the date of December 26, 2024, at the location of 2564 Deek Avenue, Pittsfield Township, Washtenaw County, State of Michigan, what'd you do that makes you think that you're guilty?
I destroyed a statue and a doorbell camera.
Okay. And so this was at a residence that you did?
Yes, I used to live there.
Pardon?
I used to live there, sir.
You used to live there. Okay, but you don't?
No.
You didn't at the time?
Not for years.
Okay. And so you destroyed those things. You didn't have any property interest or ownership in any of those properties.
I had some property at the house stored, but I was there also that day to get that property back.
Okay, I got you. But as to the statute and the Ring camera, those weren't.
No, correct.
You didn't
correct.
buy either
No.
one of those, correct?
Correct.
Okay. And you didn't have the owner's permission to destroy any of that property
No.
or do anything to it. All right. And you did that.
In this tense courtroom moment, judge calls the case of People versus Roman Hop. The defendant calmly admits to malicious destruction of property, a statue and a doorbell camera. Despite understanding every consequence, he pleads guilty, showing a rare moment of honesty and acceptance. The atmosphere turns heavy as the judge reminds him, this plea means no trial, no second chance.
Intentionally, sir?
Yes.
All right. Would you stipulate or agree that the value of those two items combined was in excess of $200?
Yes. Like
That's-
excess or it was,
Yeah, it was more than $200.
$200 or more.
Yes. Yeah.
Okay, you would agree to that?
Yeah.
Okay. Sir, if I accept your plea, in this case, I have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence agreement or evaluation in the case. You understand that?
Yes, sir.
And you would not be entitled to withdraw your plea. You understand
Yes,
that?
sir.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Before satisfied.
Satisfied, Judge.
All right. Court will accept the defendant's plea to this charge. Count one. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
November 12th at 9 p.m.
November 12th, 2025, 9 a.m.
Your Honor, I know your next sentencing date is the 22nd. I know that's a quick turnaround, but given Mr. Hop's time he's done, we are asking for the 22nd.
His time is done.
He's been in custody for quite some time. He's eager to get assessed, get seen by probation, get this case resolved. He is.
Go ahead.
Sorry. We were also going to renew our bond request that the motion was on Wednesday, and this court denied that motion. He did want to renew that request. That housing is still, present for him. We just don't know how long it's going to be available. So that's why we're requesting such an urgent date.
I do think he's still held on the felony, just so the court knows, Your Honor.
Yes, that bond's $100.
Yeah.
Is he going to be able to post that?
He thinks he may be able to. I mean, this is bond denied, so obviously this is driving the bond truck here.
The sentencing will be for the 27th.
The 27th. So the original.
Right, because he had violated the terms of his release. His advised bond was denied.
Right.
Um,
The date he's gonna. I asked for.
I just don't think, and I can't. You're basically asking 3 days from now for probation to be able to interview him and do everything, as well as talk to the victims of this, and I just don't know that that's going to happen. If I set it for that day, I don't know that we're going to have all of the information that we need. So I'm going to set it for the 12th. That
If also, so I'm sorry. I can talk to probation maybe if things are done quickly. We'll contact the court if depending on what Ms. Pilara can.
I want to lose my housing.
Yeah, we're just really concerned about the housing issue, Judge.
no, I understand that, but I
For
also
6 years.
have to try to put things on a reasonable time frame and don't want to stress my probation department either. But
I will add, if I may, regarding the bond argument. I know the court said you would consider any additional information that I was able to obtain. I did reach out to CMH to see what they recommended as for a mental health plan moving forward. The gentleman, Mr. Hop's caseworker, and just indicated that housing was their primary focus, that the CMH's mental health recommendation moving forward was to get him into housing. So they didn't have anything additional to add that he's already doing, which is he does report to CMH for medication. So I don't have anything else. I know the court requested that information. I don't have anything else to add except for that was their, primary recommendation for his, mental health journey. So again, that's why we're just trying to make things happen,
Yeah.
Judge. Obviously, the county has to do what they have to do with the housing, but we want him to be able to take advantage of it if possible.
anything else from the people?
No, Your Honor, I think I've made my position pretty clear to the court with our bond motion on Wednesday, and the court understands the struggles with secured housing,
Yes.
but also understands the struggles with bond violations that lead to new cases and all the things that are sort of going on in the periphery of that issue.
I don't see a basis on which I would change my decision. I think I would still keep his bond as denied. I'd like to see everything regarding his sentence and know as much as I possibly can about this. The events, as I understand them, are concerning to me, and then the violation on top of that adds concern. While certainly he would be going into Avalon Housing, you've talked to CMH. first thing is I'm not going to do anything until I see an absolute plan as to what some structure around him that's going to prevent further activities by him. So that's going to be one thing. But I also want to see the full outlay of it. And particularly, I want to make sure that the victims of this offense, that their views and what they might say to probation are fully considered by the court before releasing it. So I'm going to deny again the request for a bond reduction. All right.
I'll see what I can do.
All right. Thank you.
Thank you.
As sentencing looms, the defense pushes for early release, but the judge stands firm. No bond. The court demands structure, safety, and accountability before freedom. With concern for the victims and the community, the judge sends a clear message. Justice comes with responsibility. The courtroom falls silent. Judgment will wait till November 12th,